Hello everybody. So this is the last chapter on the Indian Partnership Act that we will be discussing today. This is chapter 8, which has sections 72 to 74. The title of this chapter is Supplemental Provisions, and the most important provision is relating to public notice. So the chapter has section 72, which is dealing with mode of giving public notice. So what is the mechanism that is supposed to be adopted in case of registered firms, in case of unregistered firms. Then section 73 is about repeals, and that has been repealed. Then section 74 deals with the savings consequent upon repeal. So that is retained. Then schedule 1 talks about the maximum fees that can be levied. Then schedule 2 was about the enactments repealed, and that was also repealed along with section 73. So section 73 dealt with those repealing acts, and that has been repealed by the repealing act. Then first, let us see mode of giving public notice. So section 72 talks about that. A public notice under this act is given. So in which cases will the notice be required is provided for in the first part, where it relates to the retirement or expulsion of a partner from a registered firm, or dissolution of a registered firm, or election to become or not to become a partner in a registered firm by a person attaining majority who was admitted as a minor to the benefits of the partnership. So how does the notice have to be given is talked about in the subsequent portion. By notice to the registrar of firms under section 63, and by publication in the official gazette, and in at least one vernacular newspaper circulating in the district where the firm to which it relates has its place of business or principal place of business. So now, in any other case other than the registered firm, so by publication in the official gazette and in at least one vernacular newspaper circulating in the district where the firm to which it relates has its place or principal place of business. So the notice to registrar which was there in the first portion is not applicable here. So a public notice, the modes of notice are different for registered firms and unregistered firms. So there are 3 modes of issue of notice, public notice specified for registered firms. One is a notice to registrar under section 63. Second is publication in the official gazette. And third is publication in at least one vernacular newspaper circulating in the district where the firm has its place of business or principal place of business. Then there are 2 modes that are there for issue of notice by unregistered firms. One is publication in the official gazette, and second is publication in at least one vernacular newspaper circulating in the district where the firm has its place of business or principal place of business. So it is not one of those modes, but it is all the 3 modes by which the notice is supposed to be given in case of a registered firm, and both the 2 modes in case of unregistered firms. Then what are the aspects relating to which public notice is supposed to be given? 1, relating to retirement of a partner. 2, relating to an expulsion of partner. 3, in relation to dissolution of the partnership firm. And 4, where an option is exercised by minor admitted to benefits on attainment of majority, where he can choose either to join the firm or quit the firm. Then who can give the notice, public notice? The public notice can be given by the firm which has been affected by this change, and or the partner who has moved out. Then the failure of giving notice will keep the outgoing partner and his estate liable for outgoing partner for holding out. Then the liability of the firm will be there, and other partners will be held liable because of the operation of the principle of estoppel. Then there are certain cases here which highlight the point that you have to give the notice in all the 3 modes. The first case is CRCMA versus State Bank of Mysore. Here, there was a suit for recovery of money by bank from partners of Messrs. Hilal Traders engaged in Arecanet business. So one of the partners retired from the firm on 1st January 1972, and the deed of dissolution was executed on 18th March 1972. And the information of retirement of the partner was informed by Asiyamma by her letter through. However, the bank denied the receipt of the letter. Then the business was taken over by one of the partners as a going concern with full ownership of assets and liabilities of the dissolved firm. The public notice was given by this lady, in the form of an advertisement in a Sunday edition of Kerala Times newspaper, which is called Satyanandam. So there was no proof of notice to the registrar and no publication in the official gazette as well. So it was held by the court that the requirement of public notice under section 72 has not been complied with. So the bank has the right to recover against the retired partner. And as such, because the requirement of public notice is not there, it has not been complied with, the retired partner also will be liable. So there is no proof of knowledge to the bank about the partner retiring or the partner not being a partner of the firm. Then in case of Ram Bhatt versus Leelaram Shivaram, the firm was a registered firm in which two partners expressed willingness to retire from the firm, and the remaining partners decided to continue the business. So here the notice was given to the registrar and it has been acknowledged also. However, the third party who was interacting with this firm did not know about the retirement of the partners when the firm bought rice from the partner after the retirement of these two partners. The problem in this particular case is he has only given a notice to the registrar, but he has not published a notice in the official gazette, and he has also not given a notice in a vernacular newspaper in the district where the place of business or the principal place of business is located. So he was held liable. So the court held that though the notice to registrar has been issued, it is not sufficient for compliance under section 72A of the Act. So the other two modes have not been done. So the defendant could not show that the third party was, so the liability can be escaped if the other person does not know him to be a partner. But the defendant could not show that the third party was not aware of him being a partner of the firm. So in that case, the retiring partners were held liable. So this is as far as the public notice, and it's very important principle which is required. It is a very important requirement to be fulfilled to be in a position to escape liability after the person goes out, or for the firm to escape liability for the acts that the person does after going out from the firm. So the principle of estoppel and principle of holding out will apply in these two cases. And the protection can come only when public notice is issued, and the public notice has to be issued in the modes indicated, all the modes indicated, depending upon whether it's a registered firm or an unregistered firm. Registered firm, 3 modes, unregistered firm, 2 modes. Then the next section is section 73, which deals with repeals, and it was repealed by the Repealing Act of 1938. And schedule 2 is under this section, and that has also been repealed. Then section 74 talks about savings. It's a separate section. Generally, in most of the enactments where there is a subsequent enactment coming up, there will be a common section of repeal and savings. Here, the repeal is separate and the saving section is separate. So just saving is generally normal wording that is used in a savings clause. Nothing in this act or any repeal affected thereby shall affect or be deemed to affect 1. Any right, title, interest, obligation or liability already acquired, already accrued or incurred before the commencement of the act, or where there is any legal proceeding or remedy in respect of such right, title, interest, obligation or liability, or anything done or suffered before the commencement of this act, that will be saved. Then anything done or suffered before the commencement of act will continue to be saved in spite of the act coming and the repeal of the previous enactment. Then any enactment relating to partnership not expressly repealed by this act, so that will be saved. Then any rule of insolvency relating to partnership which is not in existence, that will be saved. Then any rule of law not inconsistent with the provisions of the Partnership Act, These are also saved. So these are all the savings in spite of the repeal of the previous enactment. Then second schedule is a schedule under section 71, which talks about the maximum fees that is required. So under various provisions, what is the fee that is required in chapter dealing with the registration of firms, etc. First, for application, section 58, what is the fee? Then for modification that is supposed to be made in the firm, then dissolution of the firm, then partners coming in and going out. Then for those fees, what are the fees is indicated in this particular chapter. Then wherever the documents are given kept in relation to a particular firm which is registered, if anyone asks for a copy of the documents can be furnished, for which fee is leviable. Then inspection of the documents can be made, for which again fees can be levied. And the inspection of the register of firms where the particulars are recorded, that can also be offered for inspection. So all those, what is the fee that is specified is there in Schedule 1. And this fees in schedule has been modified by certain states through amendments, because you can see the rates, the amounts that are indicated are abysmally low. So these are the various provisions of the Indian Partnership Act, and firms continue to be in existence, and the law that governs these firms is elaborated, indicating various facets of the relationship. And a contract can always have variations from the provisions of the Partnership Act, but where the contract is not express, then the provisions of the Partnership Act will apply. So, and to know whether something is a firm or not, one has to look into the facts and circumstances of the case and see whether all the elements that are required for a partnership are fulfilled. Accordingly, you decide whether someone is a partner or not, and whether that association of individuals is a firm or not. And consequent requirements are whether registration is permitted or not, etc. Then updating of the records after registration. Then you have the rights between the partners, then rights and liabilities relating to the third parties. So relationship between the partners, relationship with third parties, mechanisms of partners coming in and going out of the partnership, then dissolution of the firm. All these aspects we have covered during the course of these lectures. Thank you.